Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome my guest for this program, Frank Tenor, who is an attorney in East Brunswick, New Jersey, and he is a certified family law attorney. And so I'd like to welcome you again to Law on the Line.
Thank you. Thanks for having me back.
I know you were here a few years ago, and today we're going to be discussing a topic that I know that you have a lot of experience in. In fact, you told me today that you have dealt with the subject of the intersection of family law, divorce law specifically, and personal injury or tort law. And so Frank, I know that's a little bit maybe for our audience something that maybe not congruent. People don't think of those two topics in the same venue. So very quickly, tell me about how you learned about this specific area of the law and your experience in that regard.
Sure. So when we say tort, I don't know if the audience will understand.
No,
tort is a civil wrong. For example, if somebody came up and punched you in the face, you'd have the right to sue that person. If your husband does it, you'd have the right to sue them in the context of the divorce. I was first introduced to what we call a TEVIS count, which is a count in a divorce for some type of civil wrong. In my case, it was assault. When an individual came into my office, a woman who told me a story about how she wanted to get divorced. She had a restraining order against her husband, and then she told me a horrific tale of how this man abused her every day of her life.
This man's her husband.
Her husband, every day of her married life, I should say.
Right. And she came to see you for a divorce.
Yes.
And exploring the issues of the case,
I said, this is horrible. You might have the right to sue him for all of these wrongs. For the fact that he punched you, pinched you, kicked you every day he did it. So first I represented her in the restraining order. And
that would be a civil prevention of domestic violence restraining order,
right.
Is that correct? Okay, go ahead.
Because he hit her in the head on that occasion. And then I went and read and said, okay, I read the law and said, you have the right to assert a claim, a TEVIS count against your husband. And in that case, she really wanted to do it because she was, for a number of reasons, not the least of which, she was a school teacher. She had this wonderful pension that her husband said, ha ha, I'm going to take half your pension because you were married the whole time that you acquired it. So that was number one. Number two, as the case went on, she really wanted to tell her story. And she wanted to tell the abuse that was inflicted upon her.
So you received a restraining order.
Yes.
And a judge felt there was probable cause to believe that an act of domestic violence, in your case, I think an assault or battery occurred.
Correct.
But that wasn't the end of the story.
That was the beginning.
The beginning. So what could you do in the divorce relative to her personal injury that you couldn't do in the domestic violence part of the case? Explain that to our audience, the difference between the two.
Okay. So the way restraining orders work is you get a temporary restraining order, which is pretty easy to get. You allege that the other party did something. And then it's supposed to be within 10 days, doesn't always work that way. You're supposed to appear at the Superior Court to have a little trial to determine whether a final restraining order should enter or not.
And this is before a judge, not a jury, correct?
Before a judge.
Okay.
And at that point, a judge has to determine two things. Number one, did a crime occur? Harassment, assault,
restraint,
civil restraint. And number one. And number two, is there a need to keep these two parties apart? If it's an assault, almost invariably a court is going to enter a final restraining order. Now, with the final restraining order, you would have the right to ask for some damages. But if it's a real assault, you're better, and the parties have been married, I think it's better to file it in the context of the divorce, because a busy domestic violence judge who has 8 cases waiting, he's not going to dig into the case the way a judge or preferably a jury will. And that's what happened in our case. I didn't bother to pursue any type of damages under the final restraining order. Instead, we filed a complaint alleging acts going back years and years and years of abuse.
So you first filed a complaint for divorce. Is that correct?
Yes.
Now, we know the answer to this, but our audience may not. Are jury trials allowed in an action for divorce relative to the dissolution of the marriage?
No. Under no circumstances,
Okay.
other than what we were calling a TVS, other than personal injuries.
And that's how you separate the two. Is that correct?
Yes. So
Now-
in this case, I filed a complaint for divorce using usual complaint. I think it was irreconcilable differences, maybe
Okay.
it was extreme cruelty. And then we added a claim for torts, civil torts. And I had like an 8-point claim. And then we laid out all of the things that he did.
The assaults, the batteries, and you described them in detail, or some detail
Yes.
in any event.
Yes.
So now you have the divorce, you have this separate count, all under the same complaint?
Yes.
Okay. And then how did the judge handle the part which was not to be heard before a jury and that which is to be heard by the judge?
Okay. So a judge has to make a determination at the way the divorce cases and civil cases proceed is there's discovery. It's a period of time where we exchange information. In this particular case, there's a 2-year statute of limitations on assaults.
Okay.
She had incidents going back years, going back to her honeymoon. This was a 23-year marriage. So to overcome that 2-year statute of limitations, she needed to be diagnosed by an expert, psychological mental health expert, with battered women's syndrome. Battered women's syndrome is a recognized medical and recognized legal malady wherein a person gets trapped. To diagnose battered women's syndrome, you need to have a 3-step proceeding. Number 1, there's a tension building proceeding. Husband starts saying, "You can't cook, this food is horrible, you got so fat," maybe pushes her a little. Next step, an explosive incident. He punches her or throws her to the ground, something that is horrible. And then the third part is the honeymoon stage. "I'm so sorry, that'll never happen again, I promise you. Here's flowers, I'm going to take you on vacation, let me help cook." And then the tension building stage begins again.
It almost sounds like the cycle of domestic violence.
It is.
It is the cycle.
So if you get caught in that 2 or more times, you can develop battered women's syndrome, wherein you feel you cannot get out of this situation. It's actually a subset of post-traumatic stress disorder, but you're trapped. And the courts have recognized that. And if a woman is diagnosed, or a man, with battered women's syndrome, since they can't get out of it and they can't seek redress from the courts have said, we're going to let you pursue allegations going back 20 years. And in my case, I had to send her out to a mental health expert who evaluated her, diagnosed her, met with collateral contacts, and she had battered women's syndrome. That got us to the next step.
So otherwise, if you can't bring the allegations of the abuse or the actual tort itself, the wrong, the harm that was caused, you're limited to what, a 2-year statute?
2-year statute of limitations, yes.
Okay.
So really, as the practitioner, you want to get battered women's syndrome if you think the person has it. I've been doing it long enough, within half an hour I could tell whether the person suffers from battered women's syndrome or not. The next step, to answer your original question, was we had discovery, then we got before the judge. in my case, I was one of the first practitioners, and the family court judge did not want to have a jury trial. Conversely, my client was adamant. She wanted to tell her story not to a judge. She wanted to tell it to fellow citizens who could render a determination as to what this person did and how he should be, to her mind, punished financially.
That'd be damages.
Damages. So the judge actually had us have a mini hearing with our expert to come in, and then determined, okay, I'm going to send it out to the civil part.
Okay, so the family law judge did not hear the case. He sent you out to a civil judge in the other courtroom.
In Middlesex County,
Yes,
it's the other courtroom.
Yeah, the other courthouse. Yes.
Yes.
Okay.
So we went out to the other courthouse, and I presented the case to a jury. We picked a jury, and she testified, and her testimony was riveting. She testified how he would beat her every day, rape her, sodomized her with the children in the other room. She was crying as she testified. And then her daughter testified. And
How old was the daughter, by the way?
at the time, she was 21
So
years
an
old.
adult.
She was a college student still.
I see.
She was actually an engineering student. She cried. She said, yes, it all happened. Dad beat me also, beat my brother, but beat Mom every day of the marriage. And I remember my last question to her was, well, why, do you still love your father? And she said, I do. I just wish he didn't beat me. And I looked over at the jury and I said, all right, I'm going to do pretty well in this case. He, of course, was a terrible witness. He's like, oh, she's making it all up. She's doing it for money. And the jury came back with an original verdict of $400,000. And they were going to give me much more because I polled the jurors afterward. But they were told that the estate wasn't worth as much as it really was because it didn't count the pension. It was, a teacher's pension could be worth $1 million. But nevertheless, we wound up then going from the civil part back to the family court judge.
So the divorce had not yet occurred, is that correct?
Nope. You have to do the civil part first. And once it occurred, we went back to the judge, and then the case was simple because basically she was keeping all the assets of the marriage. He kept a small pension, and I think he kept one little bank account, and she received everything else. And most importantly, she had her pension, and even more importantly to her, she got to tell her story and be vindicated by a jury of her peers. That was a very highly unusual case because everything had to align. You had to have enough assets to make this worthwhile. You had to have a litigant who was adamant about going forward, and not everyone is. It's difficult to tell your story even to a judge, let alone a jury.
Right. And are these hearings, especially a jury trial, are they in any way closed to the public, or is
No.
It's a public hearing? Is that
Public
correct?
hearing, yeah. In New Jersey, or aside from very limited circumstances, DCP and P cases, Children Protection Services, we have an open courtroom, and we had witnesses, and we had people just in the courthouse that were sitting in there, family members, of course, of both sides. But yeah.
So Frank, you're representing a woman in a divorce, or a man for that matter, and you said you could pick up whether or not a party is a victim of battered spouse or battered woman syndrome within a half an hour of interviewing them. What are some of the more subtle factors that are revealed in a person's interview that leads you to that conclusion, as opposed to perhaps somebody says, well, my husband punched me in the jaw and I broke my jaw, which that's a tort too, isn't
Yes,
it?
it is.
So explain the distinctions, and how would you proceed if it's just that one single punch that is admitted? Perhaps there were more, but you don't have much more proof than that.
Well, we've all represented couples that, like the battling Brewsters. He hits her, she punches him back, and they're fighting. That's usually not the case with a battered woman. Usually, she doesn't fight back, or if she does, it's only in self-defense. And then you start probing. Well, describe the relationship. Was he controlling? Were you able to, nowadays, did he track your cell phone? Did he call you all the time to see where you were and who you were with? Control is really a key aspect of a perpetrator of battered woman syndrome, or a perpetrator of a tortious issue like that.
So with the single, let's say a single act that you can prove, and perhaps whether or not there's a actual final order, restraining order, how would you approach that kind of case?
So that's more like a regular civil case. So husband punches a wife, breaks her orbital socket. Now, what is that? What's the value of that? She doesn't have battered women syndrome in this scenario. Now we get an expert to come in, a medical expert, to say, well, this is how it's going to affect her for the rest of her life. She's going to have blurred vision. She'll have to have glaucoma tests every 6 months, etc. That's when I rely upon my friends that are personal injury attorneys and say, who's the best expert to get, and what's the best way to present it.
Now, with regard to both battered women syndrome and not the syndrome, but an actual tort, which is the personal injury that's caused by an assault or a battery, that could be criminal, but we're talking only about the civil side.
Right.
How do you evaluate whether or not, and it's terrible, somebody is a victim here and they've gotten injured, whether or not to take a case? And I know that we're going to talk about, I guess, the deep pockets, and how does that work?
So these are intentional torts.
Correct.
So there's no insurance company. It's not like personal injury lawyers, you slip and fall at the ShopRite, you can sue their insurance company, the insurance company will pay. So you have to look at what the assets of the marriage are, because that's your universe of recovery. That's the first thing, not the first thing, but do I have a sympathetic victim? To my mind, I always think, what would my mom do if she was on that jury? What would she say if she heard the story this person just told me? And that really is it's the mom test. And if my mom, if I think she would have been outraged by the behavior, then I'm interested in the case. And then I look to the next step. Well, can she afford to pursue this case, not only financially, emotionally? That you can't tell on the first meeting, but you have to see if the person, because you've got to really be, it's trying, it's emotionally trying. You have to relive this abuse repeatedly. Depositions are taken where you have to do it. You have to answer interrogatories where you say, this is what happened.
Written questions that you have to answer under oath, and the
Right.
deposition is an oral interview, if you will, oral questioning outside the judge, outside the jury.
Right.
And how does the personal injury aspect, and you're seeking assets, there's no insurance.
Right.
You're seeking there's a marital pie, and it could be very large, or it could be very limited, or
Right.
somewhat limited. How does that relate to the distribution of assets that are acquired during the marriage by way of equitable distribution? And that's a legal term. And explain that real quickly to our audience, and whether or not fault goes into that equation, or a tort into the distribution of assets by way of equitable distribution. I know it's complex, but try to break it down for us.
Okay. So equitable distribution is how, in New Jersey, it's how we split things up between parties. And unlike states, community property states like California, where everything is in the pot to be split up, we look to what was acquired during the marriage, usually defined as date of the marriage to the date of the filing complaint. It is an equitable distribution, not an equal distribution. So, for example, if a husband takes his premarital monies and buys a house, takes $200,000, puts it into a house, and a year or two later finds out his wife is cheating on him, and the parties get divorced, she's not going to, in all likelihood, get 50-50 of the equity in that house because it wouldn't be fair.
Right.
So it's a court of equity. It looks to what's fair. On long-term marriages, we generally speaking do split things 50-50. Fault usually does not come into play. There's a case called Manny where it comes into play, I think, with alimony a bit, but usually doesn't come into play. But a tort claim engulfs that rule in that if you have a verdict, like I did in that case, $400,000, now we're starting with $400,000. Here's the pot that we usually split 50-50, except move $400,000 of it over to her side. Now this is what's left. And a court's not supposed to, second guess the jury and say, well, I'm going to give the husband a little more because she's taking most of the assets. The whole point is to have vindication, not only for this individual, but for society at large. We don't want people beating their wives or beating their
significant others.
So that's why this law came into being. And it's...
When you say the law, meaning Tevis claims? Or,
yes. Yes, Tevis or Tevis claims. It came into being because our jurisprudence, our judges have said, and our Supreme Court justices have said, as a society, we don't want this occurring, and we're going to do what we can to eradicate it, and we're going to right the civil wrong that the perpetrator committed.
And we do that, obviously, in this context, through dollars and cents.
It's the only thing. In a civil case, it's all it is money.
And I guess there's always a criminal component, but
right.
That's really outside of our jurisdiction as family lawyers.
Right.
It's something that the state would get involved in. We've talked about sort of overt acts of, physical assault. Are there other forms of marital torts that could give rise to a Tevis-like claim?
Sure. I had a case a couple of years ago. A woman, very devout Muslim, came to me and found out that she had been infected with the venereal disease. And she said, I have only had one partner my entire life. And I found out that he's been going to prostitutes, and I got on his phone, I got on the internet and found proof that that's what he's been doing, and I want to sue him for it.
In the divorce context.
In the context of divorce, right. And those are difficult cases because that case was unique. Person who never had sex with anybody else and was very believable because of her religious background. It happens also with people that are not so religious, and then it's a little tougher because they're entitled to, then if you're going to bring the issue of infection by a sexually transmittable diseases, the defense attorney would have the right to explore your sexual history. And some of them are very difficult because they can lay dormant for years and years, like herpes. You could be infected with herpes and it won't show up for 3 years.
I see.
So those are tougher cases. But that's an example of something other than a physical assault that you could do. And I've even done financial tortious behavior.
For example, I'm just looking at my cheat sheet here. Hiding assets, dispensing with marital assets as two. So how would that work, Frank?
Yeah. So the classic example is a guy. Wife says, "That's it. I'm divorcing you," and the next thing you know, he transfers title of the house to his brother. You then have to allege that this was either conspiracy, the word is
Purposeful, knowing.
Yeah, purposeful and knowing, and then you have to bring in the third party and bring them into the case.
That will, and plead them into the case.
Right.
Right.
And then you're suing them for their behavior, which was intended to deprive you of your assets.
Now, where do you sue that person as well in the civil side? Or
So
is that,
it all starts in the family. Everything starts in the family part. It's up to a judge as to whether it goes over to the civil part or not, or even whether you're entitled to a jury trial.
which judge? Now, the family law
The
judge.
family part judge. The reason they did that is because children. If you have a case where custody is an issue, that would trump any claim that would warrant getting a jury trial, because the court has to hear that issue. And so the court will have to decide, hey, look, this is really and not everybody is filing for good reasons or for noble reasons. She filed a TIVAS count alleging personal injuries because she really wants custody of the child, and she wanted leverage against the other party.
When or how does the judge make that determination? In your particular case, you had a history of battered spouse syndrome, battered
Right.
women syndrome. But how did you make that presentation to the judge so it could be bifurcated, go before the civil judge?
I did it by way of motion. I said, Judge, a motion is an application to the court for some type of relief. And it's before you get divorced, it's called a pendente lite motion. In this case, as we finished discovery and I said, all right, I want this before a jury, I filed the motion before the judge. The other side gets to respond to that motion.
You got 30 seconds, Frank.
And
Go
then
ahead.
I responded, and then the next thing you know, the judge says, all right, everybody come in. In this case, he wanted a hearing. In many cases, the judge will just look at it and say, all right, this is a serious personal injury case. I'm sending you out to the civil part.
Have you been in a situation, I think you said you were, where there's a intentional financial crime, if you want to call it that, hiding assets, dissipation of assets?
Yes, many times. There's a lot of guys that think they can get one over and say, well, the asset's out of our hands now, and you have to disavow them of that belief.
And that's a separate count other than just pure equitable distribution?
Yes.
Wow.
Yes.
So there's a whole avenue of remedies, and there's something that many practitioners, quite frankly, may overlook. And it opens up the eyes not only to clients who have suffered these losses, that I think may and hopefully open up the eyes of some attorneys to look at these cases not with a very narrow perspective.
I hope so. I hope this gets the word out a little. I know most of my colleagues watch your show, and I'm hoping that, that people understand that you have the right to be vindicated if you are a victim of domestic violence or of atrocious conduct.
Well, Frank, I thank you so much for, to me, a very edifying program, and I hope our audience appreciates your expertise as well.
Thanks for having me.
Thank you. My pleasure.